Nuclear verdicts have just grown out of proportion. There was a jury verdict not too long ago in California that was close to $1 billion. You can imagine the impact on a company if the company has got multiple cases. A lot of defense attorneys make the mistake of not giving the jury a specific number that they think should be awarded early on in the case. Simply arguing the plaintiff is entitled to nothing, that's not going to help your case. When a corporate defendant comes in and says, well, we don't owe the plaintiff anything, we're not at fault, that's not going to help the situation.
This is The Litigator's Edge, the podcast where smart strategy, practical innovation, and real-world experience come together to move litigation forward. Each week, we sit down with attorneys, legal tech leaders, and trusted advisors who are rethinking how great legal work gets done. You'll hear how law firms are building a competitive advantage. These conversations are grounded, insightful, and designed to help you refine how you work and how you win. Here is your host, Aniket Sawant.
Hello, and welcome to today's episode of The Litigator's Edge, the podcast where innovative attorneys reveal the strategies that have transformed their legal practice. My name is Aniket Sawant, and I'm co-founder and CEO of Threadeo. My guest today is a fearless trial lawyer with a truly impressive statistic under her belt. She has taken nearly 50 cases to a jury verdict. Krista Stoumbos is a partner at Tyson Mendes, where she leads the defense in some of the most emotionally charged and high-exposure matters in the legal system, including high-profile sexual assault and catastrophic injury claims. She uses her deep courtroom experience to guide clients through the most difficult narratives, working to protect organizations from the modern threat of nuclear verdicts. It's my pleasure to welcome Krista to the podcast. Welcome, Krista, and thank you for being here.
Thank you, Aniket. I'm very happy to be here, and what a fabulous introduction you gave me.
It's my pleasure. Thank you. Thank you once again. Krista, so I'd like to start by asking each of my guests to share either a fun fact about themselves or a cringe joke. Which will it be for you and what is it?
I'm going to share today a fun fact about myself. So I'm actually vegan. I've been vegan for about 6 years now. Growing up, I would try out vegetarianism here and there, but I've always been a huge advocate for animal welfare, and that's really guided my decision. Today I'm a big supporter of huge animal rights organizations like Mercy for Animals, Farm Sanctuary. And so I'm a big supporter of ending the factory farming of animals. So very healthy too, and great for the environment.
Absolutely. Thank you for sharing that. That's well, I as I mentioned off air, I have some family members too who are down that path, and they seem to be happy and healthy, which is fantastic. Okay, so let's now talk about the professional side of you, right, Krista? So I think of every attorney who makes the time to be on this podcast as a superhero, and every superhero has an origin story, and I would love to learn yours.
That's very kind of you to say. So when I was growing up, I knew I wanted to be a lawyer or an actor from a very young age. I'd say about 9 years old. I grew up in the Midwest, in the suburbs of Detroit, the West Side, born in Ann Arbor, and I grew up on the West Side, but I've got family all around Metro Detroit. And there's a strong history of labor unions, of civil rights struggle, of advocating for the common good, workers' rights, all of that. So growing up, I really had a strong sense of justice, and I wanted to devote my career to making the world a better place. That or acting. So I did a lot of acting as well. Loved acting. I was a dancer. I grew up doing plays. I was a ballet dancer. Loved to perform as well. But those movies, with quintessential lawyer movies, they just stuck with me. Perry Mason in the courtroom, those dramatic moments. I think it goes hand in hand, performing for the jury as well as acting. They're so similar. There's a lot of involved in being a lawyer. So I wanted to do that. So that's what I ended up doing.
That's amazing. There's so many things I want to ask because this is almost like a second fun fact about you, which is wonderful. So a couple of things. One is when I went for my first jury duty and I saw sort of the attorneys there. This is actually in the San Francisco courts, and the first thing that came to my mind, and I didn't even think about this, was, hey, it looks like this attorney is performing. And I never thought of that. It was a serious matter, civil dispute, whatever. And I was like, wow, it just struck me. So when you mentioned that, I was like, hey, there are a lot of similarities. So thank you for sharing that. The second thing, and this is, I have to ask you this, is so given that your interests and passions and obviously capabilities span acting and law, what do you think of Suits?
Oh, Suits. Everyone asks me this question, Aniket. I get it. At least the 20th time. This is a
I'm sure. I'm sure.
you asked this question. And honestly, I have not spent time watching the show. I really need to. But people love it. And friends will come up and they'll throw out some legalese terms to me that they've heard on Suits and ask me if that's actual, if that's actually correct. And so I think it's great that it gets people excited about the profession. And because there are dramatic moments. Every day-to-day moment is not as dramatic, I'm sure, as the Suits episode from what I've heard. But there are certainly dramatic moments in the profession of law, so I gotta check it out.
That's wonderful. Okay, so now let's go back to where you were in your career. So you knew from the age of 9 that this was something that you were passionately interested in. Can you walk us through your trajectory for where you turned that interest into reality?
Sure. So after high school, I had to make the decision of whether I was going to go to New York and pursue a theater career, which I was also very interested in, or to buckle down and go to university and go forward with pre-law. And so I made that decision. I settled on that. I still did a lot of performing arts on the side, but I went to Michigan State University. Excellent school, beautiful campus in Michigan, Big Ten school. It was really fun. And so I did political science pre-law. I spent a lot of time studying social science, different forms of governments. I spent a lot of time studying philosophy, writing a lot of papers. I learned there that I really, truly love to write as well as oral advocacy, as well as to orally advocate. And so it was just a fantastic experience. But that was really just the beginning. And now I look back on that time with such warmth in my heart. There were 4 years where I just was able to learn and write and expand my mind without really knowing where my career was going to take me at. I knew I wanted to be a lawyer, but just exploring at that point. And so after that, after Michigan State, I started working for lawyers to get a better sense of where I wanted to go in my career. So it just would start out like in the summer. I think there was a summer at Michigan State. I worked for 2 criminal attorneys just to get a good idea. And then after Michigan State, I actually took 2 years off before law school. The first year, I worked for a very prominent attorney in the Detroit area who was just growing in terms of personal injury work. And Detroit's notorious for having these big billboards around the city. These few lawyers will dominate the field, and they make fun of it on some shows about Detroit. So I worked for one of those lawyers. And it was great. I worked on pre-suit cases, and I really learned the advantages, disadvantages of damages. And I spoke to clients. I really got a good sense of face-to-face contact with clients, which was awesome. And then I actually traveled for a year after that. I took time off. I backpacked around Australia. I know this is a little kind of side fact, but I took time to travel as well. And so then I came out to San Diego. I had a scholarship at a law school. So I took a scholarship at California Western in San Diego. And it ended up being a fantastic program because it was really practical based. There were a lot of programs that you weren't just sitting in a classroom. They had clinic style courses, which was awesome. It's where the California Innocence Project is actually based. And so the professor who ran that, Justin, it was just phenomenal. He still works on the California Innocence Project today. And so I took that for a semester. I worked on that clinic. I took clinics where I would go appear at the public defender's office in court, actually, and got experience arguing. And I was fortunate enough at the start of my second year, I decided I needed a job. I needed to get intern experience. And I met the first great mentor of my life, Mark Carlos. And so I'm going to give a shout out to Mark Carlos here. He's one of the best criminal defense attorneys in the country. He's just amazing. I met him on my first interview. It was the very first interview. And so there was some luck involved there in coming across him. But he ended up teaching me, very closely for 2 years. So I wrote for him. I was in court with him. I attended federal criminal trials with him. I helped sign clients with him. Big cases, big white collar criminal cases, very serious murder cases that were on the news. We'd appear before the news all the time. It was very exciting. that felt like Suits to me. From what I hear about Suits, that felt like a legal drama, being in a legal drama. And so it was amazing. So mentors really shape your career. They're hugely, hugely important. I don't know if the other attorneys, I've watched some of your shows, Aniket, but I have to harp on the fact that mentors are hugely important in a lawyer's career. And so it really took off after that. I started at the public defender's office after law school, and now I am here today.
That's wonderful. One of the stats that your bio has, which is really not, at least I've not seen it that to that effect or to that level of frequency, is that you've conducted, or is it almost 47 jury trials or been a part of them? Most civil attorneys are lucky to see maybe 10% of that, maybe. So, can you talk about what your experience was like as a public defender in those trials? What did you learn from being a part of those trials, as well as from the mentors who were no doubt by your side during at least some of those trials?
Oh, yes. No, great question. Like I said, I knew from a young age that I was interested in being a lawyer, and particularly I was drawn to being a trial attorney. I knew trials were the passion for me. I was always passionate about trial advocacy. And so, especially after the fantastic experience of working with Mark, who is a, just a world caliber trial attorney, I knew I had to really jump in and get as much experience as I could if I wanted to be a great trial attorney. Now, trial work, at least for great trial attorneys, there are all various realms of caliber of attorneys, just like there are for any profession. But the great attorney it's an art form. It truly is an art form. But there's a lot of skill involved, right? There's a lot of skill that you have to obtain in order to develop your art. And so I knew right away I needed to get trial experience. Mark was a big influence in encouraging me to work for the public defender, and it aligned with my values as well. I cared strongly about justice. I cared strongly about advocating for the voiceless and in getting a foundation for doing that. I mean, people can imagine, right? There's no other situation that's quite comparable as to an indigent accused in by the government, facing the government, staring down the government, and being faced with prison time, years of their life being taken away in this intimidating courtroom, right? So you really are, I mean, standing in between the government machine and the most vulnerable of society. And so I really wanted to join the public defender. And I have to say, it was one of the most rewarding experiences I've ever had. So if anyone is thinking about pursuing a job at the public defender or the district attorney's office or any sort of public service position like that, I highly recommend it. Highly, highly recommend it. You'll meet inspiring mentors who have devoted their lives to public service, who believe strongly in justice, in standing up for people's rights, for the rule of law, for democracy. And so I highly, highly recommend it.
So that was a wonderful story in terms of your public service work. Can you maybe share your transition from public service to the private sector, and then we can talk about the work that you specifically do today?
Yes, absolutely. So I was in Chicago. So when I was a public defender, it was in Lake County, which is just north of Chicago. I was living in the city, and I take the train up to Lake County because they just happened to be hiring at the time. The Cook County public defender wasn't hiring at the time. And so Lake County was a very nice, close knit community of lawyers, old school family law lawyers too. Like a lot of the attorneys that practiced at the DA's office, we called them state's attorneys in Illinois, and the public defender's office. They had brothers or fathers or uncles who were judges, and women, a lot of women judges too. And so it was a great close knit community with a lot of ties to Chicago. And so after, when I was thinking about moving, I wanted to practice downtown Chicago. I mean, it's beautiful, exciting. I lived in the city, so I was ready to kind of make that jump to Chicago. I knew that I still wanted to get a lot of trial practice. And one of the considerations that's important early in your career is to consider that if you're going to go to a big firm, especially as a new attorney, there's a good chance that you're not going to be conducting trials. You're just not. It's just a fact in civil cases that about 5% go to trial at all. So 95% of civil cases, approximately, are settled, right? Because the goal is to minimize risk with large amounts of money. A lot of clients just aren't willing to go to trial and take that risk. So most cases settle. And so I wanted to make sure that I was still getting a lot of trial experience. So what I did was I found a job at a small firm, at a very small firm. It wasn't glamorous. It didn't seem glamorous, but I took a risk in doing this because I knew the firm had trials all the time. I talked to their attorneys, and there were about 5 attorneys there. And so it was really defending bodily injury cases, car accident cases for $50,000, $35,000. And you were in court all the time defending these cases. So I talked to the people that worked there, and I saw them in the courthouse. I went down to the Daily Center right downtown Chicago and did sort of intel before starting to work there. And I have to tell you, it was worth it in every sense of the term. I stayed there for about a year and a half, and I did at least 30 civil trials. At least. There were weeks where I was in trial back to back. I have one trial, I'd finish up the next week, I'd start another trial. There was one week, I think I even did 2 separate trials in 1 week once. It was so fast, fly by the seat of your pants, and you had to think on the spot, but that makes you, and I already had the fantastic foundation of completing at least 15 criminal trials while I was at the public defender's office. And so I was already very comfortable with trial. And so then it was just a wonderful, wonderful experience. And so when young attorneys, if you really are interested in being a true trial attorney, focus on getting that experience. Don't just go for the money right away. Don't just go for the job that seems glamorous. Sometimes you might have to put a little bit more thought and think, well, I'm going to do this job that it seems hard and it seems like a lot of work and it seems like I'm not going to be very well paid in the beginning, but wow, it might set me up later. I might be able to learn wonderful skills. And that's what I did.
That's great. Yeah, it's so fascinating that you took this deliberate step to get more trial experience and understanding the landscape of what firm size or profile or structure would enable you to do that. So that's a fascinating trajectory that you took. Talking about what you do today. So you now specialize in defending companies and other entities in high stakes civil trials, including high profile sexual assault and child abuse cases. And these are matters that are serious. Often they're emotionally charged. Can you share a moment where you realize that, hey, there's a certain approach that I need to take in order to make sure that the outcome is as good as it can be for all involved?
Oh, sure, sure. And just to segue too, so after I left that smaller office, I started working for bigger firms. After having this strong trial base, I felt that I was ready to go into more complex cases. And so I started handling wrongful death cases. I started handling a wide array of complex civil matters where it wasn't a simple accident case anymore or a crime involving 4 pages of a police report. You had millions of pages of documents in these complex cases now sometimes. And so I started doing that. And then, yes, segueing into high stakes trials. And a lot of my cases now involve sexual abuse allegations. So represent a lot of entity defendants like school boards or large religious organizations, anything really, where you're dealing with allegations of sexual abuse. And because of a recent bill that passed just a couple of years ago in California, it opened up the floodgates, so to speak, for a lot of older cases to come through the woodworks. And so what happened is a lot of cases from the 1970s, the 1980s were no longer barred by the statute of limitations. And so I deal with resolving a lot of these old cases too, which are challenging because, as you can imagine, decades have passed, witnesses have died, evidence has disappeared. And so you really have to be creative and thorough in obtaining the evidence for those cases. And so, yes, so they're emotionally charged, certainly. I think my criminal background prepared me well for this type of work. And so I'd say, especially at my firm, there are a few attorneys that used to work in criminal law and that now do this type of work because of their familiarity with crimes, with the investigative process, because we have to deal with investigators a lot. and obtaining all the evidence. And of course, when you're dealing with victims too, you have to be very careful in how you approach something. Some of the cases are very serious. And when you come across a serious case, part of the skill and the knowledge of being an experienced trial attorney is knowing early on in a case whether that case should likely be settled, right? Or if this case seems desirable from a trial perspective early on. Now, when you take on cases from the beginning, for all my cases, for instance, I prepare them all for trial. So it doesn't matter if I think a case in the first couple of months should be settled. I've got that in one compartment of my brain. Yes, this case has a lot of dangerous aspects to it. A jury would not find my corporate witness very sympathetic. All of these considerations are there. But at the same time, I'm prepping that case for trial because you never know. You never know as a trial attorney which trial is actually going to go. You can think a case should be settled, but when you start getting into settlement negotiations, whether they're direct settlement negotiations or you're working with a mediator for weeks on end or months on end trying to resolve something, you don't know if the plaintiff is actually going to accept your offer when the day comes. So you have to be ready. You have to be ready to go when trial day comes. And so while you're prepping and thoroughly prepping it for trial, you're also trying to see if there are exit strategies to take. And I think that's a truly skilled civil attorney is always thinking of exit opportunities in their mind.
That's great. Can we talk a little bit about, at a high level, of course, about some of those exit strategies, especially in the context of persuasion? So, what persuasion tools do you use with juries? How do you leverage maybe your acting skills and passion within that sort of the persuasion toolkit that you have? And then how does that typically lead to an exit strategy that works for your client and that is satisfactory to the other side?
Sure, sure. So, well, when you're thinking of exit strategies for a case, you're thinking of them continuously throughout the life of a case, right? So, a case comes in, I'd say an average time between trial and the case coming in is maybe around 2 years. Judges, courts want to make sure cases are going through the courts relatively quickly. If they're seeing a case that's 3 years old, 4 years old, 5 years old, they want that resolved right away. It doesn't reflect well on them having those old cases on their docket. And so I'd say an average time is about 2 years. And so when a case comes in and you're devising and strategizing for exit strategies, some of the things you're thinking about early on, right off the bat, you're thinking, is there a motion to dismiss that you're able to do? Is there some at the early stages of litigation, is there some argument that you can bring before a court to say that this case shouldn't even exist? So you're thinking of those, certainly. And then you're planning for discovery. You're planning to jump in and start really getting into the nitty-gritty of the evidence. And for that, you're trying to determine how is the most efficient way that I'm going to be able to get the strongest evidence for my clients to strengthen their position, right? And you're also considering at that point in time whether you think there's a chance that you'll be able to file a motion for summary judgment. And so the motion for summary judgment comes after discovery, at least some discovery has taken place. And there you're asking the court to determine that there's no issue of triable fact. Basically, that all of the evidence that exists, there's no way a jury or a judge, if it happens to be a bench trial, there's no way the trier of fact could go in the opposite way of what you're arguing, right? All of the evidence so clearly supports your argument for summary judgment that no reasonable mind could differ. And so when you're going through discovery, you're trying to get those facts out if it's possible, right? And when you're in discovery, you're also you're assessing the strength of the evidence at that point. So while you're planning for trial and you're trying to see if these motions are available, you're making the judgment call. Is it even possible to file this type of motion? Do you think this case is likely to go forward to trial at this point? And then another important consideration, of course, is just weighing the cons and the strengths of the case to set it up for potential settlement. And so there are a lot of different things that are going through your mind. There are a lot of different things. That's why analytical people are often drawn to trial work, to litigation. I love analyzing things. And so you're thinking of all these different opportunities while you're going through the case, right? Preparing it for trial, thinking if there's a way to file a motion to get rid of the case, or also at any point in time, can we just settle this? Is it in the client's best interest to just settle it and get it out of here? If it's a terrible case for a plaintiff, if it's really, really bad for them, sometimes you'll offer what we call like a nominal settlement. Maybe it's $10,000 or something just to get rid of the case. And oftentimes they might take that because they've expended costs in taking on the case. And then in discovery, they're finding out, wow, these facts are terrible for my client. This is a disaster case. I'll cut my losses, so to speak, take the nominal offer and get out of here.
That's great. Focusing on say the tools of persuasion, and I'll actually make this more concrete. So, your firm, Tyson Mendes, is famous for the methods it uses to diffuse nuclear verdicts. Those verdicts that are driven by juror anger and things like that. So, can you maybe talk a little bit about some of those techniques, maybe some that you've used or been a part of, and what that sort of looks like and how that sort of plays out? Maybe in a case that happened under your watch.
Yes. Great question. And it's such an important one today because nuclear verdicts they just blown out of proportion in modern litigation. There was a jury verdict not too long ago in California that was close to $1 billion. And this was just within the past, I'd say 6 months to a year. And so nuclear verdicts have just grown out of proportion. And so that's just for one single plaintiff. You can imagine the impact on a company if the company has got multiple cases, like, for instance, in a toxic tort case, which I often defend. In a toxic tort case, if a company has hundreds of lawsuits filed against it, and these verdicts are reaching these high numbers, hundreds of millions of dollars, you can see how that would really impact a company. And so, yes, so my firm, Tyson Mendes, just has an excellent trial reputation. We have a lot of skilled trial attorneys, which is what drew me to the firm in the first place. And so we specialize in taking cases to trial. I'd say our firm has a higher proportion of skilled trial attorneys than any other firm I've ever worked with, which is just awesome. And so the founder, Bob Tyson, Pat Mendes is also one of the founding partners, but Bob Tyson worked on a big case in California called Howell versus Hamilton Meats. And so he was the defense attorney in that case. And every attorney in California is familiar with that case because it established a big rule for damages. And so Bob ended up writing his first book about nuclear verdicts, defending against nuclear verdicts. And in it, he detailed his method for diffusing nuclear verdicts. And so there are 4 key aspects of it. And he gives seminars about this. We have tons of trial courses for young attorneys and old about the methodology of using these. And so there are 4 key components. So you have to, first of all, you have to argue a specific number of damages. You have to give a number of damages in the trial. A lot of defense attorneys make the mistake of not giving the jury a specific number that they think should be awarded early on in the case. They'll just say, basically, they'll argue that the plaintiff is entitled to nothing. Well, that does not help diffuse a jury's anger. You can imagine if there are emotionally charged circumstances, very serious injuries or aggravating facts showing really serious negligence or potential negligence against a defendant, simply arguing the plaintiff is entitled to nothing, that's not going to help your case. And so one of the key components defending against nuclear verdicts is to give a number early on. And so you're arguing right in the beginning in opening, you're throwing out a number. In voir dire, even when you're questioning jurors, you're throwing out numbers because you want them to hear it right away. Plaintiff's attorneys are throwing out these numbers right away. You need to be giving the jury your number right away too, prepping them for that, right? Making them understand where you're coming from. Because if they're only hearing plaintiff attorney's number all the time, then that's what's going to stick in their mind, right? And so giving a number is really important. Personalizing the defendant, this is especially important for corporate defendants or entity defendants, right? So you want to personalize your corporate witness. who's sitting with you at trial. I mean, almost usually they should be. You shouldn't be going to trial without a corporate witness by your side. And you want to personalize them because at the end of the day, right, companies are just people. They're groups of people and they were faced with these different issues and you want to make sure you're personalizing that witness. If the jury doesn't have personalization and just thinks of the company as a faceless, nameless thing out there, well, they don't mind issuing a huge damages award against that nameless, faceless corporate defendant. So you want to be personalizing the defendant. Also, you want to be arguing non-economic damages. So pain and suffering. A lot of defense attorneys make the mistake of not addressing that. And that's like the key component of a nuclear verdict. Plaintiff's attorneys are going to hammer in on the pain and suffering and how the plaintiff it deserves millions upon millions of dollars, right? Hundreds of millions of dollars today for what they went through. And juries are receptive to those arguments. And so you want to be putting a number and explaining your reasoning for the number of non-economic pain and suffering damages to you. And then the fourth one, probably the biggest and most important, I mean, they're all important, but perhaps the most important of the four is to accept responsibility. So the key component of arguing for these nuclear verdicts from the plaintiff's bar, right, is activating that reptilian part of the brain, getting them angry, getting them upset. And so when a corporate defendant or any other defendant, but especially corporate defendant, comes in and says, well, we don't owe the plaintiff anything, we're not at fault, that's not going to help the situation in a case with very serious facts, with very serious injuries or very serious allegations. So you want to accept responsibility. You want to accept responsibility, even if there are strong arguments, right, that the corporation or the defendant is not directly responsible, right? You still want to accept responsibility. And so every nuclear verdict, if you look at these nuclear verdicts, the defense attorneys are not doing these four things. They're not, they're missing one important aspect of them, or they're missing multiple aspects of these. And so this methodology, it really works. And so people are studying it now. And there's a reason why our clients are coming to us to handle these very serious trials. And our methodology works.
That's fantastic. Thank you so much, Krista, for sharing that framework. And as a non-attorney, it was just fascinating for me to hear how those make sense from a human perspective, right? If somebody feels like they've been wronged, legal training aside, the first thing you can do is acknowledge their feeling and not say, hey, this is because if I would imagine, to paraphrase in non-legal terms, if I say that, hey, they should get nothing, it means to me, I would interpret it as a plaintiff, as you saying, hey, my suffering, perceived or otherwise, it means nothing to you, and that will make me angry. So that makes so much sense. Thank you for sharing that, Krista. So let's talk now about the role of technology and AI in the work that you do. Obviously, it's everywhere. It's the elephant in the room, the 800-pound gorilla. So how do you and your firm use technology, including AI tools, within the work that you do, whether it's diffusing nuclear verdicts, whether it's developing those exit strategies, persuading jurors? What role does AI play and technology play in that?
Great question. And yes, it's just such a hot topic these days. We're living through such a fascinating time where new technologies are being developed every day. And so, yes, it's a very hot topic in the legal industry, as in many other industries. And so, you probably heard about in the news something that just boggles my mind. You keep hearing about attorneys getting disciplined for having fake case citations in their briefs, which is just shocking, right? It's just shocking. And so there are a lot of steps. Well, yes, we're implementing technology and AI into our everyday work. There are so many steps that lawyers have to take to be careful as well. And so we're definitely using it a lot more, I'd say, on the research side, of course. Programs like Co-Counsel through Westlaw have been just amazingly helpful. Now you can plug in a bunch of facts to Co-Counsel, copy and paste pages of information from a case to Co-Counsel, and you can even ask it, write me a letter to opposing counsel on this subject. And it'll give you a pretty nice starting draft, which is just so much fun. I mean, there's nothing like this when I was starting out as a lawyer. And so it can be hugely helpful, but you have to be so careful, and I can't stress that enough, right? To double check everything. And you can't even be using any of these AI tools, the citations, without actually checking them. So co-counsel is one where you can verify. You could plug in a bunch of information from a draft brief that you have, and you could ask co-counsel because it's Westlaw's from one of the major research providers, Lexis, Westlaw. You can ask it to verify your case citations. But all of this double checking, it's just hugely important nowadays. And then for trial work, there's a lot of really interesting technology that's coming out. For instance, I heard recently of a plaintiff's attorney who had used some form of recording, so of the dead client, of the dead plaintiff. So they had used AI to develop some sort of, I don't know if it was a video recording or an audio recording, but of the plaintiff to use in front of the jury. So the jury, I mean, obviously that's very persuasive for a jury and emotional for a jury to be able to hear a plaintiff speaking who's obviously not there. And so I think we're going to see more and more of that implemented. I can imagine the first thing I was thinking about was like holographic images. What if we'll have actually people running around in the well in front of the jury one day and they're AI generated? I mean, I think we're going to see all of that stuff, but the rules can't be developed fast enough to regulate it. So it's an evolving process on both ends.
Absolutely. That's great. So Krista, as I'm reflecting on our conversation so far, I think we focused obviously most recently on technology, and then you mentioned all the different process elements, if you will, in terms of developing the strategies that you've used in your career. Let's talk about arguably the most important and the third component, which is people. So you lead a multi-attorney team. Throughout our conversation, you shared some guidelines for younger attorneys. But specifically speaking, how do you in your day-to-day course of work teach the younger attorneys on your team to develop the skills that are necessary to be strong litigators and in fact strong trial lawyers in the same manner that you are?
Awesome question. And so, yes, I think that as well, at least for myself, and I know from other mentors that have mentored me, that as we get more advanced in our career, it becomes very, very rewarding to be able to mentor young attorneys. And so I think it's an important process to, at least for myself, when I'm mentoring someone, I like to find, of course, someone with a good attitude. And so I can't stress enough for younger attorneys how important it is to sort of put your ego aside when you're learning at a young age. At a younger attorney age, I should say, as a baby lawyer, as we like to say, to put your ego aside because you're going to make a lot of mistakes. Everyone does. Everyone does. I think after COVID, with all of this remote work, that's certainly a challenge that is faced with young developing attorneys because a lot of this hybrid work, it doesn't make it super conducive to learning trial practice, right? So I'd say I'd like to have face-to-face time with my team. Not all the time. Of course, you can work from home as well. We appear in court over the computer a lot these days, as I mentioned to you before, Aniket. And so you can work from hybrid. But an important aspect is to have this face time. And I try to take them with me as much as possible for trials, for important motion hearings in the courtroom. So you can really get the sense of thinking on the spot because that's an important skill to be able to handle. And so I really want them to have the confidence and the strength and the skill set to be able to think on their own on the spot and to get used to doing that. I think that's one of the most important things.
Fantastic. Thank you for sharing that, Krista. This has been a wonderful conversation. I've learned so much from all the things that you've shared. Final question for you. Is there a question that I should have asked you, but I didn't?
Thank you, Annika. And I have to say, this has been really, really nice experience for me as well. Um, I've never had a podcast experience where I'm talking about myself or my career as the main focus. So this is the first time for me for that. And thank you. It's been a wonderful, wonderful experience. So yes, I'd say considering what we're facing here today in the United States, I have to say that the question would be, this is another hot topic that's being talked about in legal circles all over the place right now, is that what can we do as lawyers? What can we do to help protect the rule of law in the United States? The rule of law is under threat today in this country as it never has been before. So independent judges are being threatened all of the time. And a prominent international bar association just determined that lawyers in the United States are endangered. And so it's a very harrowing time for us as a country, but especially for lawyers. When we're admitted to the bar, we take an oath to uphold the Constitution. And so I think it's my personal opinion that it's all of our duty as attorneys to advocate to protect the rule of law today. And so in response to that question of what can we do, I'd say there are a bunch of things that you can do. And the most important thing is to do something now, and to not sit on the sidelines any longer, because the time to act is now. So you can start, first of all, speaking to your friends and family, speaking to your colleagues, speaking to your communities about the importance and what we're up against, the severity of it. You can be using your social media platforms to help advocate, to raise awareness of the problems. Of course, there are a lot of nonprofits you can get involved in, the ACLU, and a bunch of other pro-democracy nonprofit organizations where you can donate your time. You can also help author amicus briefs for one of the hundreds upon hundreds of serious cases that are going on throughout the country right now to protect our democracy. And so I think it's really important. I hope I'm inspiring at least some of you to go do that today.
Thank you, Krista. Yes, I mean, there's certainly a lot going on, and I appreciate your sharing that, and I'm sure our audience will as well. So, again, Krista, this has been a wonderful conversation. Thank you for your time. Thank you for your insights, and I look forward to seeing you again at a future episode.
Thank you very much, Aniket. It was my pleasure. Thank you for having me, and yes, look forward to speaking with you anytime.
The Litigator's Edge podcast requires more than a conversation. It takes action, research, and collective wisdom. If today's episode resonated with you, we'd love to hear your insights. Join the conversation and help us shape the future together. We'll be back with more stories, strategies, and real-world solutions that are making a difference for everyone. In the meantime, be sure to subscribe, rate, write a review, and share it with someone you think would benefit from it too. Thanks for listening, and we'll see you on the next episode.